Welcome to our channel Legal Dost by UB Media. I am Advocate Siddharth Singh and I am a practicing lawyer in Madhya Pradesh High Court. Today I am going to talk about writ petitions. Writ petitions are filed under Article 226 and Article 32 of Constitution of India before the High Court or the Supreme Court. I will tell you the basic concepts as to when you can approach the High Court or the Supreme Court for filing a writ petition. Basically, I'm going to cover first the High Court. Generally, what happens is that you go to a government department to exercise a right. They will either not do it, they'll delay it, or they will decide it wrongly. Now, you will be left with no remedy as to, for example, you have filed an application under MPLRC. Now, the concerned officer is not acting on your application. He's delaying it or he's extending it for unknown reasons. So in that case, you can approach the High Court saying you have filed an application, but the government officer is not doing its duty. The High Court in that case will give that government officer a direction that you please decide that application within 60 days, 90 days or 30 days, whatever period High Court will deem fit. Now, for example, your application gets decided and you see that there is no provision for appeal, but the order has been wrongly decided. Now, in that case, what to do? So there is this another writ called, it's known as writ of certiorari. A government officer or an administrative tribunal, when decides your case so wrong that it is patent, that it is bad in law and illegal, then you can approach the High Court and tell them that this is the correct law. The case decided by this government officer is wrong on these points and it is apparent. And then High Court will quash that order and either decide it on your behalf or remand the matter to be decided on the following points, whichever the points are right as per the High Court. Now, what happens sometimes, a government officer will initiate a proceeding which he does not have power to do it. He does not have the jurisdiction. But for his ignorance or for his malafide, he might be inclined to pursue such an proceeding against you. In that case also, you can approach the Honorable High Court for issuance of a writ of prohibition that this person or this authority does not have jurisdiction to proceed with this case, and at the threshold itself, not at the order or at the expense of litigation. This order may be continued, but it should be stopped at the threshold itself. Now, before approaching the High Court or deciding when to approach the High Court for writ petitions, it is very important that you approach a lawyer who practices in writ petitions and constitutional law. You have to understand few things. First, you have to understand that you have no other remedy. For that, you need to understand which statute or athenium is under play. You have to understand which section is governing your case. Once you understand that law and you see that once your case is decided, is there any alternative remedy? Is there a provision for appeal? Is there a provision for review? If there is a provision for appeal or review, you will have to file that appeal or review in front of the appropriate authority. But if a case arises that there is no alternative remedy and the order is wrong, because generally what happens, administrative tribunals and administrative officers, they are not very well versed with law and they might make mistakes which are patent in nature. In that case, since you do not have any alternative remedy, you can knock at the doors of the High Court and ask them that I have nowhere to go. Please decide this order which has been wrongly passed in against me. For more informative videos like this, follow our channel Legal Dost by UB Media and subscribe. Press the subscribe button.